are there 10 people on this committee or 8?
10.
Okay. So you don't have a quorum.
Wait, let's just think of that.
So you can't take any action.
We don't have a quorum live, right?
Right, but
two,
that
three,
means you don't have a quorum.
1, 2, 3, 4, 5. Teresa Wood will be coming in a little bit.
Okay. I mean, I don't think you need to take any action on anything, but just so everybody knows, and I learned this through the hard way, and
Yeah.
is I was staffing a protection oversight, child protection oversight. They had only a couple members in person, and so that we're not supposed to do that.
Right.
So just letting everybody know.
Yep.
The earlier you can let people know that you're either going to be in person or remote is good. So we know ahead of time if we have a quorum.
So we are live, and I want to apologize to folks who are waiting for us to watch us on live at 10. We had a little bit of a delayed start waiting for folks to come into the room, the physical room, room 11 here at the State House. We do have some committee members who are with us remotely. Representative Shaw, Senator Sears, and Senator Lyons. So with that, I'd like to get started with our legal counsel, Michelle Childs, to really talk with us about some of the testimony and the issues around expansion of expungement and sealing of criminal records. Our duty as a joint legislative oversight committee is to consider how to simplify and automate the process of expungement and sealing of criminal history records. So that's one of our directives. And also we need to consider a comprehensive policy that provides an avenue for the expungement or sealing of the records for all or most of the offenses, except those listed in 33 VSA section 5204A. So we have to make some recommendations for this coming legislative session. We do not have a physical quorum here. We need one more member to have a quorum. So if there's any votes or actions that need to occur today, we may hold off on that until our next meeting next month, depending on, I know Representative Wood is due to come in at some point. Representative Maxine may scoot out at noon and come in Zooming this afternoon. So we'll play it by ear. Okay, so Michelle, welcome.
Thank you.
And if you could sort of give us, I went over the committee charge a little bit.
Well, that's where I was actually going to start. So, so for the record, Michelle Childs, Office of Legislative Counsel. And I just want to have a little caveat at the beginning, which is, as you know, Bryn has historically worked on this issue and has a really deep knowledge on this. So I am coming to it new and fresh. And I can say in my 20 plus years here, this is definitely one of the more complicated things. And I don't think it's just because it's new to me, but you know, I think what's happened is over the years, the sealing and expungement law has been amended kind of piecemeal in a policy way. And so sometimes so I think what we have is a rather complex system that includes both expungement, so meaning elimination and destruction of the record completely, and you have options for sealing, which is that is not available to the public, but it is accessible by certain designated folks. And so going to, Peggy, can you put up the slide for S7, Section 5, the directive to Justice Oversight for me, please? The last one there, the last one. Yep. And just go to, I think, page 4. There you go. Great. Thank you. So the chair was addressing a little bit about the intro for this. And so the directive to this committee is to propose legislation for 2022. So there's no report, but they are looking for a draft bill. And there are 4 things there that are, I think, should be your focus in a very kind of high level way in discussion. Again, because aside from folks who have sat on judiciary in the last few years, it's hard for everyone else, including me, to just kind of pick it up and know historically all the things that have been tried and changed and things like that. And like I said, it's pretty complex, but I think if we can go through the 4 questions and get a sense of that, I can start drafting, and then we can start adding some pieces, and you can start having some witnesses come in and address some issues where you need to see some additional options. And so the first one is this issue about whether to make all or most criminal history records eligible for sealing or expungement, except for this reference there is to what we refer to as the Big 12, and those are the offenses for which a child can be tried as an adult. So except for those and any other offenses the committee deems appropriate. So I think the first issue is knowing that you have a 2-track system now, and there are certain crimes and there are certain conditions under which you are eligible for expungement versus sealing. And do you want to kind of stick with that 2-track system? Or do you want to move toward having one system, that being sealing, but look at your definition of sealing and maybe adjust that somewhat? So right now, Peggy, can you go to, I think I sent you kind of the chapter for, if you go back to my name on there and you pull up, I'm sorry, we're not, the technical problems are preventing witnesses from directing the laptop, so it just may take a little extra time there. So just the chapter.
Yeah, I have to go, I sort of have to go back to.
That's crazy.
Oh, sorry. You can't keep that committee tab open?
Yeah, I guess I'll try and do that.
So I think probably what you have is the first, no, maybe not. So yeah, unless that's a bill, it says S7. Can you click on that?
713.
Yeah. Is that just the existing law? Yes.
Yes.
Can you please click on 7607? So I just wanted to direct your attention to what you have in current law with regard to the effect of sealing. And so, I think, and we can go back, and the section above before that is on expungement, but I think generally people understand expungement. Expungement means it's gone. There's no access by anybody. But for effective sealing, there is the kind of public face of it where the record is treated in all respects as if the person hadn't been arrested, convicted, or sentenced. But there are avenues to access the record. And so then you have an existing law, the provisions there that talk about who has access. And so that, from what I've been hearing, has been the kind of discussion around, do you want to stay with 2 tracks? Is there a value to you from a policy perspective in saying that some records should be sealed, but others should be completely eliminated and no access ever? Or do you want to have 1 track and trying to simplify it? Because that's one of the goals here, is to try to have a less complicated system and say, well, going forward, let's have it all be sealing, but let's look at what sealing means and under what conditions. So I know that one thing that's been expressed by some of the witnesses that I heard before was, if you went to sealing, some of the witnesses were concerned, well, they don't want, let's say, a law enforcement officer that's just doing a routine traffic stop to pull up and see that someone has, a completely unrelated conviction for something that, doesn't doesn't concern with regard to the motor vehicle issue. So like, how do you thread that needle saying, we want to do sealing, we want there to be clear options for certain people to access certain records at certain times, and what are those circumstances? But then generally, it's as if the record does not exist, and go that approach. So that's the first question. And I would say it might be helpful maybe if the chairs of judiciary talk a little bit about, because I haven't been in on the testimony or things like that. So
I agree to that. But I have one question with the sealing of records. So currently right now, a record can be sealed. Is there a time after that that record could then be expunged?
Yes.
So
They're
that's
like
right
based on
now.
timing or certain conditions and things like that. And there's a whole mechanism in the existing law for how that can happen.
So you could go from the seal, your record
you could go
is
from a
sealed
sealing to an expungement.
to an expungement. Can you also go directly to an expungement?
Yes.
So there's, okay. Okay. I'll turn it over to the two chairs. I don't know, Senator Sears or Representative Grad, who would like to kind of direct this conversation a little bit.
Peggy, can you take that down just so you can see the people maybe?
Okay. I think Representative Grad would like to defer to Senator Sears first.
Well,
Like,
okay.
yeah,
Yeah, that's fine. You know, I would say, to clarify, the sealing was done originally so that we could get at certain crimes that have predicate offenses. So, for example, DUI. We were one of the few states where DUI isn't a lifetime. So you could get a DUI when you're 18 and get one when you're 68, and it'd be your second offense. We actually went to sealing because you'd want to have that extra record. But then we put a timeline. I can't remember exactly what the timeline was on that, on DUI, so that if 20 years had passed, I believe it was, then that DUI is expunged, the initial one, but you can't get a second one expunged. So that was really one of the areas where we did sealing. What we found was, and one of the disturbing things for me was the openness of sealed records, particularly for juveniles. I've always told juveniles their records are sealed and are not available, and yet we find cases where they are open. And I'm talking criminal now, actually delinquent records for delinquents, and the nature of the crime that they may have been charged with. And so sealing is of concern. Is the major concern for us is who has access to the sealed records. And you'll find that as that gets debated in committee or in this committee, that'll be the key issue. I think it's a lot simpler to seal than expunge, because expungement means going after every record of that particular crime, going all the way back to, and that was difficult for the courts. That's what took so much time for the courts. And sealing is easier for the courts because you're basically sealing the record. But I would say that I'm fine with looking at a sealing situation. The key point is who has access to those sealed records. Now, one argument would be that people who are doing research should have access. They wouldn't have access to the name, but they'd have access to the record. But in a small state, if the crime occurred in Bristol, Vermont, maybe an awful lot of people knew who that person is.
So Dick, am I understanding, because this is a whole new topic for many of us, we don't live this in our committees. So are you suggesting that we do the one-track system where we just seal the records and not do expungement at all?
Yes, as long as we are careful in who has access and what sealing means and what it doesn't mean.
So
For
let me get-
example, the bankers may want access to anybody's record who had a embezzlement in their record. They may
Mhm.
want access to other issues. So do we do that? And then what is the impact of sealing? A sealed record, for example, would not be, you could still say that you did not have a criminal record. None exists. That would be the state.
Sheriff, and then Maxine?
Maxine, because you want to follow.
Yeah, no, I just want to say that I certainly agree with Senator Sears that sealing is, a one-track system is much simpler. And in many states, whether it's sealing or expungement, they are the same. They're often used interchangeably. So, yeah, and like Senator Sears said, it's really a matter of who has access to those records and for what purposes. And as long as the person who has that record, as long as the effect of sealing or expungement is the same, that's really important.
And I'm just wondering if we go to the one-track system, which seems like a reasonable thing to do, can we maintain what is happening now with sealing as far as expungement after a time? And then my second part of that question is how do you affect that for people who committed a crime 20, 25 years ago, as this law is put in place? Would they then have their record essentially expunged? And then the third part of my thought here is about the research, and can't we keep the information regarding crimes as far as research goes by redacting names and not having names available?
I'll start with the easiest one, probably because it's the last one you mentioned, which is research. Sure. I mean, there's provisions in existing law with regard to retaining information, special indexes that are available for research purposes. And that exists in both the expungement and the sealing statute. So that's current law. So we can figure that one
So
out
that's
for
not
sure.
a
I
not
don't
a-
see that as an issue. And can you restate your first question again?
Can
If
we, I'm trying to
I
think.
think you were saying if we go to a ceiling, would there be an opportunity for
Right, after
expungement
a
later? I mean,
time.
that would be keeping a two-track system. That's
Okay,
what we
so-
have now.
So, well, right now, though, if a case is sealed,
Mhm.
then is there not time for expungement afterward?
It depends. There is time. There is time, but I think what I've heard folks looking at is saying that perhaps if you limit the record and who can see the record under what conditions, then maybe expungement isn't really necessary, because for most purposes, now I'm not advocating this, I'm just saying that trying to talk about the policy issues, is that if it's not available, like for an employment check, or if law enforcement officers, just running your plates or something like that, it wouldn't come up, but maybe it needs to come up if it's a DUI or certain other things, is that it's kind of nuanced based on the offense. But the issue, that's certainly a policy decision for you guys to consider, is whether or not you still want to keep expungement for some things. And if so, what's the policy reason behind that? What does expungement get you that the newly crafted sealing wouldn't get you? Because right now the sealing, there's a lot of access to the records under our current sealing process. I think what I've heard people talk about is let's kind of create something in the middle between our current sealing and our current expungement, so that the record's not completely gone, but that we have more limited access to sealed records.
Can I just basically, one of the basic things we miss when we just talk about this, there is a certain period of time to be eligible for sealing or expungement. So it's depending upon the criminal act that you were convicted of, you have to wait until you're completely off probation, So all fines have been paid, all surcharges, etc. Everything has to be taken care of. And then there's a certain wait period, and it depends on the criminal act. So you've already got a period of time before anybody's even eligible for sealing or expungement. Then you can apply, and the state's attorney basically has a veto over the expungement or sealing. And once you apply, and then you go, and that's when you get to that sealing. And so it may be that DUI occurred when you were 18. By the time you're 22, you've completed everything. Now you wait another, I think it's 10 years, and you're eligible to apply to have that record sealed. And then a certain amount of time goes by, and that record can't be used against you as a second offense. As I started out saying, you were 18, you got your first, and if you were under prior law, when you were 68, you got your second offense, it would be a second offense, even though there's 40 years that had elapsed.
So if we do a one-track system, which I'm hearing the two chairs of the committee that you're going to be working on this, that's really the direction you would like to go and look at. So one-track system, sealing of the records. Need to really address who has access to those records. What's also going through my mind is a way of getting to that one-track system, kind of melding some of the criteria that's currently being used for both expungement and sealed records, to kind of meld that together in a workable way for sealed records only. You know what I'm saying, Michelle?
Mhm.
That's what I'm picking up in the conversation here. Am I off track?
So,
Nope.
Madam
Okay.
Chair,
Yep, Butch?
I'm trying to keep this straight here. So I think I'm hearing Senator Sears say, basically, the expungement, we should concentrate on the sealing portion of the statute and not so much on the expungement. But I also think I just heard him say, and I think you alluded to it, that after a certain period of time, maybe a sealed case should be eligible for expungement, and using the DUI as an example. Am I still on track here?
I'm not,
Well, if you have the DUI, which is different from other crimes, where you have a DUI 2, 3, 4, whatever, then I think you have to have a certain time limit where that predicate offense is no longer used. And you have domestic violence probably wouldn't be part of this anyway. So probably a bad example. But DUI is probably the best.
So there are certain crimes that could
But
be.
you could do it so that
Yeah.
in the DUI 1, after 15 years after completion, when it's been sealed, and then another 10 years or 15 years goes, then it's no longer, it's sealed tighter in terms of who has access.
So then I also think I heard you say, Senator Sears, something about telling a youth that their case is sealed, but yet it's really not sealed.
Right, that's a problem that we uncovered when we were starting with all of this.
And we
So
should.
all juvenile delinquencies are supposed to be sealed, but there appears to be ways to get those records.
Okay.
And that is something that we should also deal with.
Okay, so we're going to.
My opinion, that's just my opinion.
Sure. Well, we should be looking at that also.
Yes, that's my opinion.
Thank you. Thank you, Madam Chair.
Jenny?
Yeah, thank you. So are there currently, what are the current rules? Are there currently rules around expungement and sealing that the judicial system has put in place? because obviously there must be conditions around a number of certain crimes. So I'm trying to figure out how we can make a recommendation for all conditions for possible sealing or expungement. And are there already rules in place or that have been considered about conditions?
I think
Those
Judge Grierson could answer that one probably
Okay.
best. But what the judiciary does now, if there's an expungement order, they go through every record that exists.
Wow.
That'll be easier when everything's electronic, but they have to go through all the records and redact everything about that record. So you take Johnny Jones, who had a breaking and entering when he was 20, and he's now 35. The state's attorney, the courts, everybody's agreed it should be expunged. You got to go back and find every record of that B&E and clear it out. Whereas if you seal, you're just sealing that record. You don't have to go back. That was the simplicity.
Okay, but in terms of generalizing decisions, so suppose Johnny Jones' decision, it was sealed, and then Eddie Smith's was expunged. Do you have are the different conditions under which that happened somehow inform the decisions going forward? Seems like it's an individual case analysis. Is that what it's going to be? I guess that's my question.
I think Michelle can help clarify this.
Senator Lyons, I think you're asking about how does the court make a determination that someone qualifies for either sealing or expungement? Is that what you're asking?
I am, but then once those decisions are made, do they inform subsequent decisions? Just trying to sort out how.
With regard to those types of offenses. So if you
Yes.
look, so we have an existing chapter 230 and title 13 that
Okay.
sets all the criteria for qualifying for either expungement or sealing. And Peggy, if you don't mind, can you put up 13 VSA 7602, I think? Right. So I'll use this as an example. So if you go to, our online statutes directory, you can see the entire chapter there. And this is the section for process for expungement and sealing of records post-conviction. The next one is when there is not a conviction. So if somebody was arrested and maybe went to trial, was acquitted or charged or dismissed, there's another provision. But what you have in this 7602 goes through and lays out all the different scenarios for, depending on what type of offense it was. How long ago was it? As Senator Sears said, have you completed the terms of the sentence? Have you paid any restitution that's ordered? And depending on the type of offense, depending on the length of time the offense, was in the past, things like that will put people into either an expungement or a sealing category. And so those are all what's contained in here. And we could go through each one of those. I will just warn you, it's very dense.
I
And
want to go
it's,
through it in depth.
and so
Yes.
what I think in talking with the judiciary chairs about is we were hoping to kind of have a general broad discussion about a direction that then would allow me to start a draft for you. And then we can start pulling in those little details, right? And focus on that. But there's a little bit that this is so dense that you spend all the rest of your meetings kind of trying to parse through the existing. But if we can try to decide on, do you want to take a one-track approach? Do you want to look at, I could just put in something around a placeholder around the ideas of who has access to the sealed records, right? So it could be that for DUI, there's a different access to that record than there would be for retail theft, or things like that. And there is precedent for that in the existing law from, policy things for you to consider, and also in some of the legislation that was moving through last session. And I think we can try to kind of boil it down to the kind of the big issues, because I think there did seem to be, from when I was reviewing the materials, some agreement on the types of things where there should be access. So crimes, there's a Chapter 64 in Title 13 is the sexual exploitation of children. So that is something that's been highlighted, I think, by a lot of witnesses as well as pairs, as something that they would want to have some law enforcement access to. Domestic violence offenses. So, when you have an officer that's showing up to a call, so that they know whether or not there's a history, they can assess the seriousness and the threat to the victim in the case, things like, so there's certain types of things that we can kind of bring forward and say, okay, here's some crimes that have been highlighted by witnesses. Do you want, certain folks to have access, and at what point and for what purposes? So who and why? Because right now, it's pretty broad in the statute for sealing. It's basically law enforcement officers can use it for law enforcement purposes. So pretty broad. But we can look at maybe some other states, and hear from some witnesses who can say, well, it's appropriate in this circumstance, but it's really not appropriate over here. And then you guys can kind of weigh some of those on the access point.
So let me take a stab here because I'm looking at the time and I know we started about 15 minutes late and we've got some folks in the queue for some other items. So I'm looking in terms of what we need to do as a committee for recommendations. And I'm picking up that we would support a one-track system for sealing, not do the two-track that we're currently under. Is that correct? That's what I'm thinking of. So if we do that, we've addressed the third bullet under our charge. So then the question becomes, well, we are recommending a one-track system and we look at sealing of the records. The next question is, who would have access to that sealed record? So that would then need to be addressed. The next one would be, should we continue with number one, where the Big 12 would not be eligible for sealing of the records? Are there other offenses that we would deem not eligible for the sealing of records? And then the other issue is, what is the process for obtaining a sealed record? Is it through a petition or do we not require a petition? Those are the simple high levels that I'm seeing. So we've already made a decision, one track, sealed record. The big issue is who has access, what crimes would not qualify for a sealed record, and how does the person get to a sealed record? Is it through a petition or not, or a different process?
You got it.
They got it.
Excellent. That sounds really good. I just want to
So
make
start
sure
drafting.
that in your talking about crimes that are not going to be eligible, that we do include some that have not been eligible before, but may be eligible. Is my understanding that retail theft has not been eligible before?
I believe that's true, but I'm not, I'd have to go back
Okay.
and look.
I'd
But
like to look
this-
into some of those.
By just exempting the Big 12, you are bringing in a lot of other crimes. So,
So- Michelle,
yes.
maybe what we could do, if people are amenable to this, you could start working on a broad draft.
Mhm.
And I would recommend you work with the two chairs of the
Sure.
Judiciary Committee, so I'm sure you already are. And it might also help us to know what offenses are in those Big 12.
Sure. And I
To
can,
help us focus on-
when I go back to my desk, I'll just email that list to you. And I think actually on number one, you might, I don't know if the chairs maybe have a proposal or an idea about number one, but I think it's, in addition to the Big 12, again, those other issues like the sexual exploitation of children or things like that. I know there have been discussions of that, so I could include that in the draft if
And
perhaps
highlight it.
Representative
The
Brad had
highlight
a
where we need to
suggestion.
Make those policy recommendation.
Right, I think draft 2.3 from Happy History, that would be also a good place to look in terms of the misdemeanors and the domestic violence and some of the other things that we heard witnesses testify
Okay.
about, and that we had looked at excluding from expungement. But then in that draft, there are crimes
Whoops.
eligible that weren't for, so.
So this is,
Can I
Sure.
just clarify that, Michelle, you said sealing is essentially clearing the record for that particular person so that it's not going to interfere with their getting a job or,
Unless you, I mean, it's going to basically allow that person to say, I don't have, a conviction for this or that type of thing, unless you say for purposes of licensing, this type of licensing or background check that's required for whatever, that there's certain things that, unless you create that exemption, then that's correct. But the idea of sealing is that there would be limited access, but very kind of
that's where you get
specified.
back who has access.
Right. Who has access and why do they have access? Because you want to be very specific, not just about the who,
But why?
but under what conditions, for what purposes.
I think it would be, well, I would just mention that, and Maxine can clarify if need be. I think one of the problems the administration had with the original passage of S7 from the Senate was a provision that allowed the sealing or expungement of people who had embezzled from public, like towns or the state or whatever. And that was one area where they were really, as I recall, that was one that they pointed out. And then the banks were really concerned about other forms of embezzlement, whether it be from towns or cities.
So those are the nuances that I would really lean to the judiciary committees, but
Yep.
I think also, Michelle, we would have to address with some grandfather language or something about folks who are currently have their records expunged or their current records are sealed. How do we deal with that arena?
I think for expungement, the records are expunged. So,
So the lay of the land changes once the law changes. and
yes.
For
So,
those situations. going
right. So,
forward.
my understanding it's a compromise, right?
Mhm.
Because some things that would be eligible for expungement now would, by adopting this one tier system, only be sealed, but sealing could very well mean something, or it sounds like it will likely mean something different than what's under current law, which is pretty broad access law enforcement.
But do you have enough direction from the committee?
I think,
our
let me
next meeting?
tell you what I think I think I could do, which is I could start a draft. I'm inclined to just start fresh and repeal all
Mhm.
of chapter 230. And I don't know if some of the people who work with it now would have concerns about that. I would encourage them to reach out to me if they do, but I feel like we should just scrap it and start over with something much more simple. And I can do that. I can use some of the existing definitions. I can look to what Representative Grad had said about what would qualify, what would be qualifying offense, exempting some of those things that we talked about. I could, create the system that it's a one track for sealing, and then just put in placeholders for who has access to what offenses and under what circumstances. And that perhaps at your next meeting, you can have folks come in and talk to you about or testify or offer suggestions about, well, we're DCF and we need access to these records for these purposes, or law enforcement needs in these particular cases, or things like that. And then they can present their arguments to you and you can weigh where you want to, from a policy perspective, can include those in the next draft. I think also for the next meeting, the issue of automatic expungement. So there's a lot, obviously, a lot of that relies on the logistics, how we can pull that off with all the different systems talking to each other and what the court is capable of and what they would need to do something like that. And so I would suggest, again, that's something that you put on your agenda for next meeting, is to have that, is to kind of really focus on the issue of who has access and when, and how would an automatic system work, and thinking through about, well, what's worth, are there some things that worth automatic, and then other things that really it needs the prosecutor should be involved in the process, and can we get those into two camps and move forward on that. So I would say those things, I feel like you need to hear from folks kind of making their pitch to you about which direction to take. And then, but then I can just, for the next meeting, I can have the framework for what you're dealing with.
Yes,
And
that
people
would be
can
great.
comment on that.
And I think it would be important, we don't get involved with the minutia, because that is the real committee
Yeah.
process of the House and Senate judiciary. We can just lay out the broad framework.
Yeah.
Does that make sense? Because we could spend all our time on this and we've got
Yeah.
other issues.
But one
Sure.
kind of minute detail, you've mentioned automatic expungement. Are we calling this sealing, or are we calling it expungement?
You
Okay.
can come up
Say
with
that
whatever you
copy
want. I think
seal.
probably sealing, because it's going to be I think my understanding is that even in places where there's no access except for, research purposes, it's still kind of just called sealing. I think I'm open. I don't have any strong thing, but I would think this is more of sealing of records, and then there's just tiers of access to those sealed records. And there could be some where the only people that get to see them is for, accuracy of records or research or things like that. And then others could have, much broader kind of what you have in the sealing statute now, where Leos can see it all.
So for next meeting, Michelle, to really help on this, if you could coordinate with both myself and Peggy.
Sure.
In terms of figuring, and also the two chairs, the Judiciary Committee, to figure out who have come in and testify.
Sure, that'd be great.
Okay. Anything else on this? As we-
I just suggest, well, I've got everybody here, that Maxine, myself, Michelle, and perhaps Peggy, and maybe yourself, Madam Chair, could meet remotely and kind of go over this for the next meeting.
That would be helpful.
If Peggy could do a doodle poll or whatever, find a time for us.
Great. So anything else before we move on?
Thank you, Michelle.
Thank you, Michelle.
Sure.
Now we're going to shift gears quickly to Eric Fitzpatrick. I'm kind of moving along because I know we're going to lose some committee members possibly in the afternoon, and we'll gather some others, and we did start running a little late. So we're going to shift gears to Eric Fitzpatrick. There has been a lot of conversation before our committee about the youthful offender status, raise the age terminology, what that means. And Eric, we just like a real clarification of those two terms and how they're used, possibly interchangeably. And just to clarify, what is a youthful offender status? What is raise the age? Are they one and the same, or are they totally different? So Eric.
Yes, thank you, Madam Chair, and good morning, everybody. It's Eric Fitzpatrick with the Office of Legislative Counsel, here to talk, as the chair just indicated, hopefully to help the committee understand the difference between the two concepts of raise the age and youthful offender. And as you were indicating, Representative Emmons, that the concepts really are different, but they are related. There's certainly a relationship between the two, but they're two different things, so they shouldn't be used interchangeably at all. I don't know if that's one of the issues that has come up sometimes.
Should or should not be used interchangeably?
Should not. They're two different things. So in the big picture, maybe it helps to sort of look at it from 25,000 feet to start with. But when the term raise the age refers to the overall policy initiative by the legislature to raise the upper age of juvenile jurisdiction past a person's 18th birthday. So that's what it is in a nutshell. It's this overall policy initiative that, it's been going on since, say, 2016. It really kicked into high gear in 2018 with Act 201. I think that's when it most sort of expressly came into view. But it started to at least take the first steps in that direction in 2016. And this initiative has been going on since then. And as I say, it's an overall policy initiative that's been encompassed by changes made throughout the juvenile statutes in Title 33, many different statutory changes, but they're all serving this one goal and this one policy initiative, which is encompassed by the term raise the age. And that means, as I mentioned, it's this change and development through law that the legislature has undertaken to raise the upper age of juvenile jurisdiction past a person's 18th birthday. So if you think about it, until relatively recently in time, the upper age of jurisdiction over a juvenile in the family division was 18. A person, in order for the family division to have jurisdiction over somebody, the crime had to have been committed when the person was age 17 or younger. So if you think about that for a moment, if the crime has to have been committed when the person is age 17 or younger, that means the upper limit of juvenile jurisdiction is the person's 18th birthday, right? Because if you commit the crime when you're age 17, but 362 days later, say, technically speaking, the family division or could still have jurisdiction over the person because they have not yet turned 18. Now that doesn't mean, it's also true, and in fact, I just heard the committee mention the Big 12 offenses, for example. In addition to the age factor, the other sort of variable factor that goes into whether a person is charged in the family division or the criminal division is what offense is it? What have they alleged to commit? And for example, Big 12 offenses, your more serious offenses like murder, kidnapping, sexual assault, arson, those sorts of things, those could be filed in the criminal division and still can, even if the person is younger than 18. But regardless of that point, the family division, the family court, what has this upper threshold, this upper limit. And up until, relatively recently, a few years back, that upper age limit was 18. Raise the age refers to the process that you've talked about a lot in this committee, in which the legislature has spent a lot of time working on, which is to raise that 18-year-old age limit. I should mention that if you think about the recent history of this, the choice up until the late 1990s was either go to the family division or the criminal division. In the late 1990s, the legislature introduced a third option, and that third option is youthful offender, and it still is. So this concept has been preserved, even though some of the details have been changed and when youthful offender kicks in and that sort of thing. But the differences between the two things are exactly that. Raise the age refers to the overall increase in age. Youthful offender is a third option that can be used with respect to a young person who allegedly commits a crime. That it's almost a hybrid between the family division approach and the criminal division approach. When it was first enacted back in the late 90s, it's still pretty similar to the way it was now in many ways, but it was, and I should say, I say the criminal division, but in the late 1990s, the criminal division didn't exist. It was the district court, actually, where the criminal proceeding would be initiated against a person. But that's when it would happen. If a young person, say, committed a Big 12 offense and they were the case was brought against them in the district court at the time, now the criminal division, the state's attorney could offer, and that's an important point that's different now, but back then the state's attorney had to be the one to agree to and offer this third option known as youthful offender. And the way that option works, or at least back then, it's somewhat similar now, a little bit different, but the idea is very similar. The youth would plead guilty to the offense in the district court, the criminal division now. They would plead guilty to it, but the case would be transferred from the criminal division or the district court to the family court. And then the person would have juvenile, would be treated as a juvenile offender, even though they've already pled guilty to the offense in the district court. They would then have juvenile probation imposed. They would have these conditions that they had to apply to. And if they completed all their conditions satisfactory, then the case would have all the advantages of being treated as a juvenile case. They would never have a criminal record. They would successfully be discharged from juvenile probation. The proceeding would remain confidential. You would have all those advantages. That's the carrot, in a sense, that was being offered to the person to plead guilty in the criminal court. On the other hand, if they didn't comply with their probation, if they violated the terms of the sentence, the case would be transferred right back to the district court, to the criminal court, and since they had already pled guilty, they would be just transferred there for the imposition of the criminal sentence. So you see, it was a carrot and stick approach. It still is. That general structure is still the way it exists in current law, but it's a third option for the person to, if they can comply with the terms of their probation, if they can, perhaps the offense with which they were charged, maybe if it was something that they can, involve sort of reparations, whatever the probation might be imposed upon in the situation, if they can comply with those terms, that's the incentive that's offered to them, then they can have the benefits of confidentiality, of not having a criminal record, not having any of the collateral consequences of criminal conviction. All of those things are available to the person if they can essentially modify their behavior to comply with those terms. If they don't, then the case is transferred back to the criminal division, and potentially, the way the law is now, potentially the court could impose the sentence that would have been the case if they had been tried in the criminal court in the first place. So it's sort of a carrot and stick approach, but the idea is similar to as it was when it was originally introduced in the 90s. As I mentioned, nowadays the transfer can happen without the consent of the prosecutor. The youth, him or herself, or through their attorney, they can file a motion with the criminal division to have it transferred to the family division for treatment as a useful offender. The court itself, the criminal division, can on its own motion transfer the case back to the family division for treatment as a youthful offender. So it doesn't require that although the prosecutor can as well, of course, but doesn't require prosecutorial consent anymore. But still, that general structure is the same, and that there's a motion could be filed. One other last point, just sort of a procedural point, but it's sort of an interesting one as well, because this is also a change from the way it was when it was originally enacted. Under the raise the age, as I mentioned, this sort of general concept of increasing the maximum age limit at which a person can be charged as a juvenile. In 2020, that age went up from 17 to 18. So as of now, a person could commit a non-Big 12 offense. I should emphasize that. If it's a non-Big 12 offense, then right now that proceeding has to start in the family division. Used to be, as I mentioned, the maximum age was 17. Now it's 18. As of July 1st, 2022, it's going to move up to 19. So a person, again, and if you can be charged as a juvenile when you're 19, which is what's going to happen on July 1st, 2022 for these non-Big 12 offenses, that means, again, the upper limit is the person's 20th birthday, right? Because if you could be charged as a 19-year-old, that means the upper limit is the day that you turn 20. So if you commit the offense anytime before that, a non-Big 12 offense, then you the proceeding has to start in the family division. However, if for Big 12 offenses, right, that's that list we just mentioned, and the person's age could be 14 to 21, sometimes 12 or 13 as well. If it's a Big 12 offense, then the proceeding has to start in the criminal division. There are circumstances under which there can be transfer back and forth between the divisions, but it has to begin in the criminal division if it's a Big 12 offense, with one exception. And the one exception is the state's attorney can choose to file the proceeding as a youthful offender petition in the family division. So I bring that up because that's just sort of, it's procedural point. It's maybe a little bit more in the weeds than you want it to go, but it's worthwhile knowing that this youthful offender process can start in two different ways. I mentioned the first one already, which is that the state's attorney or the defendant or the court can all motion to transfer the case from the criminal division to the family division. But option number two is the state's attorney doesn't have to file it in the criminal division at all. If it's a Big 12 offense, then the state's attorney can choose to file it in the family division, but it has to be a youthful offender type proceeding. Can't be a juvenile proceeding. If it's a Big 12 offense, the only way it can be filed in the family division is if it's a youthful offender proceeding. And as I just mentioned, that's a hybrid. It's a little different. And if that's the case, there's a hearing, the family division holds a hearing to see whether or not, I believe it's called a youthful offender consideration hearing is the name of it. Has to have a hearing to determine whether or not to proceed with the matter as a youthful offender. But the result is very similar to what I described. There'll be terms if they do consider it as a youthful offender proceeding, their juvenile probation is imposed. And if the youth complies with those terms, then the case will ultimately be dismissed. The records will be sealed. The proceeding remains confidential. They'll have no collateral consequences of conviction. If they don't comply with their probation, then the case can be transferred back to the criminal division, and the person can be sentenced for the criminal offense. And that's the stick in the carrot or stick scenario that I'm talking about. The idea is to incentivize the person to modify their behavior, improve their behavior by providing them with this positive incentives of the juvenile disposition. And essentially, that's what a youthful offender proceeding is. So you can see it's a very distinct and separate proceeding than the overall concept of raise the age, which is and it's true that as as part of raise the age, the age limits in the youthful offender proceeding have raised, also, because if you're raising the age generally as to whether or not a proceeding can be brought in family court, that goes along with the youthful offender piece as well. But conceptually, the two things are different. It's a general description of the increase of the age threshold for juveniles, which is raise the age, or a specific proceeding about how young people can be treated in the criminal justice system under certain circumstances.
Thank you, Eric. I'm trying to follow you. I got it, but then I lost it, and then I got it again. So
Good.
We have a question, Senator Sears.
Yeah, I just want to thank Eric for clarifying all of this because I think it's important. There's a lot of confusion about the two. Actually was working with a victim of a crime and they were wondering why this young person was treated as a juvenile. And actually what happened was he actually was 19, not eligible to be a juvenile. And his lawyer had applied for youthful offender status, and that hasn't even been decided yet. The state attorney is fighting it. So, there was just confusion because the state police told the victims that the person was considered a juvenile because he was 19. It's still part of the law, Eric. Am I correct that the person has to be amenable to treatment? In other words, they just can't get youthful offender if they just want a better deal but aren't interested in treatment or making changes, etc. And the treatment needs to be available. Is that still part of the law?
Yes, absolutely, Senator Sears. There's three findings the court has to make, and you just identified two of them. They have to be amenable to treatment as a youthful offender. Services have to be available in the court system, DCF and DOC. And the court also has to find that public safety would be protected by their treatment as a youthful offender. So those three requirements are right there. You're right, you can't just automatically apply for it. The court has to hold a hearing and make those findings.
Other questions? I don't know if it's more confusing or clear. But we'll keep working through it, Eric.
Yes,
one
well,
thing-
if you have any follow-up questions or want to talk about it some more, happy to come in anytime.
Great. One thing that Maxine mentioned, maybe we could have a chart at some point to see if that could lay out the differences or the similarities. I don't know. if that
Yes,
would-
it's funny. I was thinking, as I was putting my notes together, I was thinking the same thing. I didn't quite do it for this time, but it occurred to me that in a situation like this, it could be helpful. So yeah, I'd be happy to do that.
Yeah, if that could happen, we could work on that and just do it as a handout for our next meeting would be helpful.
Sure, we'll do.
Okay.
Yeah,
sure.
it would also be helpful if people that work in the system had that copy of the chart, because I think that's where part of this confusion comes in, particularly with changes in law and et cetera.
Yeah.
So, Eric, before you go, this may seem like a really silly question, but is there an age, an upper age for youthful offender?
Mhm. 22, 23.
Yeah, I believe it's 22 now.
22, okay.
Yeah.
You had mentioned 21 and said that if it were changing, if raise the age was changing, it would affect that. Okay.
So
Yeah.
22, but once they reach their 23rd
Third
birthday.
birthday.
Or is it
Uh,
their 22nd birthday?
Right. That's a good question. Or is it 22nd birthday, age 21? I'm not 100% sure about that, actually. So before I,
Put
Give-
that in your chart.
Yeah.
yes, I'll put that in the chart. Absolutely.
Anything else? Okay, great. Thank you, Eric.
You bet. Thank you. Bye now.
So let's keep moving here. We did at our last meeting have some conversations about staffing issues. And what really brought the conversation to this next piece was testimony we received from Commissioner Brown from DCF about the Beckett proposal and how some of the concern in that area of the Beckett proposal was that once that program got up and running, might be pulling staff away from some other entities that are providing services in that part of the state. And that brought up the bigger issue for many of us in terms of will that happen where once Beckett possibly gets up and running, it's going to pull staff from maybe the local mental health agencies or other entities there. And also, what's the overall issue within the Agency of Human Services in dealing with your staff? And, you know, everywhere we look now, there is staff shortages, and it's hard to recruit or retain folks. Is that an issue that's happening across the Agency of Human Services? And I know we're going to work more later within DOC, but the first discussion we wanted was the overall plans of how to address staffing issues within the Agency of Human Services. So I'd like to start with Deputy Secretary Jenny Samuelson. If you could start us off, and Senator Sears, if you could run the committee for a few minutes while I take a quick break, and I will be right
Certainly.
back.
We'll do my best. So I guess since I'm just looking for the agenda, I guess we'll start with Commissioner Brown. And Jenny, if you want to join him and together on this one, that's fine.
One of you can get started. I'm not sure which.
Yeah, you're muted, Jenny.
Senator Sears, are you asking us to start with Beckett or the overall Agency of Human Services?
Start with Beckett and then go to the overall agency and the problems, but also problems with contractors with the agency. I know here in Bennington, there's been difficulty finding staff for certain programs that contract with the state.
So I will hand it over to Commissioner Brown to discuss overall Beckett, but to kick us off, so folks are aware, Beckett is running the 6-bed residential juvenile facility in Wells River. Currently, they're finalizing their budget and their staffing plans. They can, Commissioner Brown will speak more to that. It's my understanding that they will be recruiting from the local area for individuals for those current positions, which we realize will impact and cause natural kind of natural shifts in terms of where staffing are coming from. But Commissioner Brown, do you want to take it from there?
Sure. Thank you, Deputy Secretary, and good morning to the committee. And for the record, my name is Sean Brown, Commissioner for the Vermont Department for Children and Families. Thank you for the opportunity to be here this morning. As the Deputy Secretary indicated, we're still moving forward with Beckett to develop and start up a 6-bed secure residential treatment program in the town of Newberry. A part of that, we submitted a plan last fall, which we can share the link to, that kind of had the overview of their staffing plan, which would include, line staff for 3 shifts during the day, 7 days a week, and then also program leadership staff and clinical staff as well. The facility is actually going to be very uniquely located to draw from several different labor markets, given where it is in Newberry and off of I-91 and Route 302. It'll be able to recruit from the Barry labor market, the St. Johnsbury labor market, and the White River labor market, as well as just locally in the Upper Valley itself, but also across the river in New Hampshire. Beckett runs several programs in the nearby area over in New Hampshire and Pike, and then a little further east of there, is my understanding. And so they have experience recruiting in rural locations, and they anticipate that they may draw some staff from some of their existing programs in New Hampshire, but that they also hope to draw staff from those different labor markets. And given their experience recruiting in more rural settings, they believe that they'll be able to recruit. One of the indicators, that in developing the budget with them and their staffing plan, we are going to pay a little higher wage than is in the local market area there. We're anticipating our frontline staff will start out at around $21 an hour as an average, with supervisor positions as high as $24 an hour. And then also market rates for the program director, the clinical director, the clinician, and some of the other education staff that will be hired to help run and educate the youth in the facility. At this point, we're not opening the facility yet. It's still in development and going through the permitting process. And so we don't have a lot of updated information to share with the committee, but I believe in the coming months, as we move through the permitting, that we might be able to be in a position to share more information with the committee. But at this point, we don't have any information that would suggest we're going to draw from other programs and impact other programs that might be in the area. But I think we'll get more experience with that once we start implementing the operational plan and the staffing plan to open the facility late next spring, early summer.
Thank you. Are there questions for Commissioner Brown?
I don't see it.
Oh, you're back. I
I'm
can't.
back. I
Oh,
know.
thank you.
See, now I'm back. So let's transition to Jenny.
A quick question. You mentioned that you would provide us with a plan. So I'm just asking if you would please do that.
Sure, we'll send the link to the report that had the staffing chart in there and the proposed wages and the different positions that would be employed at the facility. We can resend that link to this committee. So
Thank you. Terrific.
Anything else before we transition to Deputy Secretary Samuelson? Hey, Deputy Secretary, if you could help address just overall issues in terms of staffing issues within the agency itself. We just wanted to have an update on that.
Great. Thank you for having me. For the record, I'm Jenny Samuelson. I'm the Deputy Secretary for the Agency of Human Services. You should have received a chart this morning that would indicate where our current staffing levels are within the actual agency. I can share my screen if that would be helpful to put that chart up on the screen.
Refresh your screen.
Refresh the screen. We can access it here, so I don't think there would be.
Within that chart, as you can see that our highest vacancy levels are within the Department of Corrections and within the Department of Mental Health at 15% and 21% respectively. Our state, as you mentioned earlier, is not currently an outlier on workforce issues. Across the nation, many industries are experiencing vacancies and challenges with recruitment and retention. It's important to keep in context that shortages in corrections officers and mental health care workers is a problem across the country. Although the Department of Health also currently has a rate of 15%, that can be a bit deceiving. VDH recently received an additional 69 positions, and of those 49 they've received since April of this year. These positions are currently under recruitment, and many of them are being filled as we speak. For reference, their typical vacancy rate is between 6 and 10% versus the 15% that they currently have now. There's also a variety of different types of positions that the Department of Health has been adding, and within the context of those 69 positions, they include epidemiologists and laboratory scientists in order to respond to the current COVID pandemic. So I'm going to transition over to addressing corrections. As for corrections, Commissioner Baker will be here shortly, and I'm going to highlight some of what corrections is currently doing, but I'm going to defer any of the questions to him when he comes in for testimony later this morning. Currently within corrections, there are 1,049 positions. Of these, there are 163 vacancies across all of the sites. I can tell you that those staff vacancies and shortages are most acute among correctional officers at our 6 correctional facilities. The total currently at total, there are 283 out of 378 correctional officer positions filled. It's worth noting that of those 95 vacancies in the correctional facilities, 30 of those vacancies are positions that were created in January of 2020 by the legislature and don't have any funding associated with them, and so subsequently have not been filled. So what's corrections currently doing to address the problem of the vacancies? We are doing paid advertising on Facebook, streaming services, including Pandora and Spotify. We've also published radio ads on popular radio stations here across Vermont, and we're running TV ads in order to recruit additional correctional officers. We've also established recruitment bonuses for individuals who are hired by DOC to attend the Correctional Academy during the months of September 2021 through March of 2022, and hoping that will increase the number of individuals coming into the academy. Lastly, we're reaching out to recruit retirees to come back on as temporary correctional officers during this period of time. Commissioner Baker can definitely provide you more details on these efforts when he comes in to testify later if there are additional questions on it. Now, thinking about mental health, currently there are 282 positions at the Department of Mental Health. Of those, 221 are filled and 61 are vacant. These are state employees who work for AHS. This doesn't include our healthcare workers that are designated mental health agencies or supported services agencies that make up part of the ecosystem of the broader mental health statewide. Our Department of Mental Health staff in those positions are spread between the central office in Waterbury, the Vermont Psychiatric Hospital in Berlin, and the therapeutic community residents, with the majority of the current vacancies coming from the state hospital. 61 of the vacancies that I mentioned are spread across all of those locations. We do hire traveling nurses, and that's been a primary strategy to fill in the Department of Mental Health vacancies. At the Psychiatric Hospital in Berlin, we're currently using 16 traveling nurses via contract and 1 per diem nurse. So there's a total of 17 temporary employees through traveling or contracted employees at the Psychiatric Hospital. At the therapeutic residence in Middlesex, we also are using 1 additional traveling nurse. Having a shortage of mental health staff has been an issue for many years, and it's well before the pandemic set in. That said, the pandemic has certainly added to the problem by making the jobs of mental health care staff harder as they take care of people professionally in their work, but also are competing with the demands and the stress of COVID in their personal lives. And again, as I mentioned at the top, this is not a Vermont problem. There are shortages of healthcare and mental health staff across the country and internationally. So I'm going to pause there. It looks like Senator Sears has his hand up.
Yeah, if it's all right, Madam Chair, I do have some questions. I'll hold on any questions on corrections until Commissioner Baker's here, but first question is regarding the mental health and the number of vacancies in our local designated agencies and how that's impacting the delivery of mental health services, which impacts all the other agencies, human services, as well as communities. I mean, everything you read regarding the current situation, for example, in Burlington, which I'm not that familiar with, but you read in the paper about mental health problems there and not being addressed. And they become criminal problems. We know that a number of people that are in corrections are related to mental health issues. I think we're at a crisis stage in this state. I know Commissioner Brown has a number of agencies that he contracts with, which are down in staff so much that they've had to reduce population. But I'm particularly concerned about the mental health because we just put in $4 to $5 million in new initiatives for mental health. But if we don't have the workers to do the jobs, all that money is going to sit there. And what are we doing to help our community partners? I realize there's a nationwide shortage of workers. I mean, I realize that, but I think we're at a crisis stage here, and it is impacting everybody else, everything else in the system. So, could you look? What are we doing about that?
Yeah, Senator Sears, I share your concern. We've been monitoring the vacancy rates of our DAs and our SSAs across the state. They employ about 5,000 people and have about a 15% vacancy rate at this point in time. Currently, the Department of Mental Health has launched a strategic planning group within the context of the Agency of Human Services, led by our community health, our mental health agencies. Participants include the Department of Mental Health, DAIL, and the DAs and SSAs specifically to address this issue. Strategies that they're looking at include supporting an educational pipeline, tuition reimbursement, compensation based on education and responsibilities, increasing training and clinical support, increasing the use of the career ladder, communicating other educational opportunities for that workforce, and statewide marketing. These are things that are underway and currently under consideration by that group that is working to address the issue.
So I would just say that much of what you're talking about is the result of the work that we did in our committees of jurisdiction, as well as in appropriations, to ensure that federal dollars were expended appropriately and that we have some incentives for folks wanting to work in the area of mental health, particularly in our DAs and our SSAs. So this has been a collaborative effort, but the issue about having people wanting to move into this area continues to be a huge challenge. It is a high burnout area. Young people leave their jobs after a short period of time, and it's hard to find those experienced replacements. So I think obviously this is a crisis for all of us, particularly in a time of COVID, where we're seeing young people challenged with mental health issues, and including it with putting in the summer program for kids to ensure that they had the support services that they needed. So, I mean, it just opens Pandora's box right now. But I do have a question, if I might, Madam Chair.
Yes, go ahead.
So you mentioned having traveling nurses that have been placed in our psychiatric hospitals. We have how many traveling nurses are there? And what's the differential in pay between if they are hired by the state or if they're travelers? I mean, are they paid at the same contractual level as our VSA folks, or is this a different pay scale?
Yes, thank you for the question. Currently we have 17 RNs total who are working at the psychiatric hospital and 1 at the Middlesex facility who are traveling nurses. The difference in pay scales have been a challenge across the state for recruitment. I can say that our traveling nurses get paid significantly higher than our current VSA nurses. I can get you the exact amount. That contractual amount has changed significantly over the last couple of weeks because as we have seen other hospitals increase their current rates for their traveling nurses, the state has had to subsequently do that in order to be competitive and recruit with the goal of making sure that we open beds in our psychiatric hospital to alleviate some of the pressure in other hospitals in the state.
So the other question I have is in terms of our contracted healthcare services, maybe I should ask this of James Baker when he's here, but contracted health services, are they seeing openings and vacancies for their healthcare workers in corrections?
Senator Lyons, that's a great question. I will defer to Commissioner Baker when he comes. I do know that they have vacancies and have been considering the use of travelers in corrections, but I'll allow him to quantify the degree to which that is the case.
Well, I mean, I guess one of my concerns has always been the delivery of healthcare within the Department of Corrections, within the facilities, and ensuring that our inmates have access to the same level of care that they would were they Medicaid or other Medicare recipients. So it's just, it compounds the problem.
Mm-hmm. Yeah, I will defer that to Commissioner Baker when he comes. I do know that that we have been able to stay on top and are confident in the system. I share your concerns in ensuring that we make sure that the community level of care is delivered in our correctional facilities. But I'll defer to him for the questions about where they are staffing wise internally.
Thank you. Senator Sears, I didn't mean to interrupt your questions, but you triggered a lot.
I triggered memories, and but you know, I appreciate your comment because I do believe it's a crisis, and I believe that it's one that we really need to deal with, and with all due whatever we can do, we need to do. And I think a lot of it is salary levels for entry-level positions are much too low to entice people to get into the field.
So, Deputy Secretary, in looking at this chart, I know in some of this situation, this question may not be relevant because there is a lot of turnover of folks, like particularly corrections and mental health. But in other arenas in the state, we're really seeing an aging population of our employees and an older population that will be retiring. Is that having any impact within the Agency of Human Services where you're seeing folks aging out of their position and not being able to fill that position with new new recruits, new employees?
That's a very astute question. I think that the Agency of Human Services is experiencing the same thing that other industries are experiencing. As we come out of the pandemic, there are individuals who are retiring. Some of the workforces we're most concerned about are younger workforces, but we are seeing retirements. We're seeing individuals seeking normal career advancements. We're seeing people reevaluate their priorities during the pandemic. And also new opportunities that have arisen from the pandemic that are contributing to the workforce challenges. I don't think that anything that we're seeing is unique, specific to mental health or the healthcare arena. Sean, Commissioner Brown, do you have anything to add in there? You see it through some of the work that you do with the SSAs and the DAs.
Yeah, and I would say it is a broader issue than just to the designated agencies or the SSAs. Senator Sears is correct. We're seeing some challenges in some of the providers that work with our youth in our care and custody, but also we're seeing it with state employees as well. We're seeing retirements, and then we're also seeing the impact on younger workers as well, particularly with children and managing and might having to change their hours or move to a different position or role or outside of state government. So, the challenges are across the board. And I think, one of the strategies we're using is, wages are important, as Senator Sears has said as well. And we're currently working with several of our providers to make sure that we're focusing on rate increases so that they can stay competitive salary wise, not only for recruitment purposes, but also for retention purposes as well, so that you're not setting up this dynamic of you're bringing in new workers at a higher rate of pay, and then you have seasoned workers whose salary is lagging. We want to make sure there's parity there. We're recognizing whether you're a seasoned longer term employer or a new one, that we're valuing the work across the board there and making sure we're treating everyone equitably. And so that's some of the work we're doing right now as well. And then just as the Deputy Secretary said, the pandemic has taken its toll on our workforce. I mean, our staff are tired. They've been working at 1,000% for the last 18 months. And it's been certainly a challenge for them. And so just making sure we make time for staff for wellness and to refresh and recharge, because we've been running on all cylinders for quite a while, nonstop. And so I think making sure we're giving staff the opportunity to recharge is important as well.
Any other questions on the Agency of Human Services as a whole? I would like to transition to Department of Corrections, and I know we have Steve Howard here, the state employees, and I'm wondering, Steve, if your testimony could be after DOC and speak both about the Agency of Human Services and DOC. Does that work? Anything else? So let's transition to Commissioner Baker. Commissioner Baker is here. Welcome. And for many of us, we've been well aware of the struggles with staffing in DOC. I remember last year, the concern was we don't have a recruiting problem. We have a retention because of a lot of overtime requirements. And now it seems like it may be both. We don't know. But welcome, Commissioner. And if you could start addressing our concerns about staffing.
Thank you, Madam Chair. For the record, my name is Jim Baker. I'm the Interim Commissioner of Corrections. And, following along the lines of what Deputy Secretary Samuelson talked about, she provided you the numbers. I'll add a little bit more context to that. These numbers really haven't changed much since the last time we met. But we also are carrying 60 positions that we don't have access to. Now I'm talking specifically about corrections officers in the facility. That's where our challenges are. And I'll go back to what Senator Sears says. These are crisis situations that we're dealing with. that we're managing every day inside corrections to keep the facilities running. And I think the last time I was here, I talked about this. This is starting to put pressure on our ability to supervise in the field. You know, we have 5 people hospitalized right now as of the beginning of this week. So we have 5 individuals in custody who are in hospital. That's 24-hour coverage to cover them at the hospital. So the pressure is now on our probation and parole offices to be able to backfill and cover transportation, hospital coverage, and that's putting enormous pressure on our district offices. So we have 60 more individuals on the security side of the house that we don't have access to put into rotations to cover shifts. And that's because of workman comp cases, FMLA, military deployments, and people who are out on leave from duty because of active HR investigations. So, you know, this is across the system. Now, we started a class today, an academy class. I believe the number is 13, excuse me, yesterday, not today, the 13th. Excuse me, we started on the 13th and there's 16 in the class. Now, 16 doesn't make a big dent in what is a total of somewhere around 190 people that we don't have access to be able to fill shifts at a facility out of a number of about 373 corrections officer 1s and 2s. So it is a significant challenge. And many of the folks from the probation and parole offices and others are filling in. You heard the deputy secretary say that we've built a list of retirees who are interested in coming back to work part-time shifts. We've contacted people who have left, and there's a handful or so of people. For example, there's one young lady who left to start a family. She's interested in coming back on a part-time basis, you know, to work around childcare and so on. So we're exploring those possibilities, but it's a very challenging environment. I've said this often since I've been here. You know, corrections officers do not get the recognition they deserve. You know, I say that coming from my background in law enforcement. I mean, when I was a road trooper in Bennington County, everybody knew who I was. They would often complain to my wife about getting a ticket for me. They knew who I was. That's not the story of corrections officers. They put a uniform on every day. They go behind a secured facility, and they are faceless to all of you and to all of the public. And the recognition sometimes plays a big role, as I talk to corrections officers around the state, plays a big role in how they perceive themselves in the system. Now, we just negotiated a side letter with the union, and I'm sure Mr. Howard's going to talk about that. That is a significant side letter. It involves significant money. And it was renegotiated with them as a side letter for 6 months in order for us to do something about retaining and stopping the bleed of staff leaving corrections. You know, early indications are that people are satisfied with that. Just as an example, if someone works an 8-hour shift, we're giving them $50 extra to work a 8-hour shift. When you do the math on that, that's $6.25 an hour. You know, that's a significant amount of money. And that's just one of the enhancements that we agreed to with the union in a side negotiation in order to stop the loss of staff from the facilities. But the long-term solution to this is complicated. These are not easy jobs. And I'm going to go back to what I heard Commissioner Brown say. The pandemic has beat our staff up bad. They are tired. They have worked countless hours away from their families. And I have a Wednesday call every week at 3 o'clock that anybody in the department can get on. We update staff about what's going on in the department. And then there's a question and answer period where folks can talk to me about what their concerns are. And last week we had a staff member do a presentation to the folks. So he started out by saying there's 336 hours in every 2 weeks when you do the math. So 336 hours in 2 weeks. Somebody came on the line and said, in the last 2 weeks, out of those hours, I had only 90 hours to sleep, spend time with my family, and do other tasks. That's the kind of impact that we're facing. And that's why we agreed to do a side letter in order to try to stop the bleed of staff leaving. Now, I'll repeat what I've said over and over again. I know other departments and other agencies and even some of my former colleagues in law enforcement are telling me they're having a hard time getting people to apply. That's not what we're finding in corrections. We are getting applications. But I will tell you, since we've instituted, you all heard me talk about this, as some of the stuff that we've been working on for the last year and a half, we've instituted background investigations. And we're starting to wash people out in those background investigations. You know, when I first got to corrections, there was a saying. It was the ice cube test. If you put an ice cube on somebody's head, it's melts, a warm body will hire them. Well, we've suffered some of those consequences as a result of that. And now that we've instituted a background investigation, out of this last class, we washed out 7 candidates because of some things that were very troubling. Misogynist behavior, some white supremacist behavior that we washed out of the process. So we are getting applications and we are processing, and I'll be more than happy to go through the entire list of things that we're doing to try to mitigate the staffing crisis. My concerns now are that, you know, as COVID continues on and we have facilities locked down and we continue to have to test. Look, this staff has been unbelievable. I mean, I kind of chuckle a little bit when I hear all the conversations about mandatory testing or mandatory vaccinations and employees will have to test twice a week. My God, my staff's been doing that for a year and a half. Every time we have an outbreak in a facility, they're tested every 3 or 4 days. And so that has taken a toll on the staff. And we're doing everything in our power to try to find ways to recruit people and get them in the door. The deputy secretary did talk about, you know, part of the agreement with the union on the side letter is a hiring bonus. Starts out at $250. So as that class entered yesterday, we gave them $250. They complete the academy, we're going to add $500. Completion of their probation after 6 months, another $750. And if they're with us for a year, we'll give them another $1,000. So we spread that out in a step because we have found that taking a look that people leave fairly shortly after leaving the academy. This is a very expensive proposal that we agreed to. But it was at the point where sitting as the commissioner, and I'm not speaking for Secretary Smith, but as I briefed Secretary Smith and the governor's office on this, this is what we need to do right now to retain this staff, to keep security in our facilities. There was a question, I think Senator Lyons had a question, and I'll get ahead of that and answer it. Our healthcare contractors having the same problems that every medical facility in the state is having. They do have problems retaining staff, and they do occasionally use traveling nurses to fill in. But that's part of their issue to deal with when it comes to staffing the facilities. So they do have challenges with staff. And I will say that I will defend the health care that individuals get in my custody. I just told you, we have people in the hospital. We had a young lady give birth the other day. We have transgendered individuals that need special medical care that we provide to them. And we work really hard to meet those needs and those challenges that those individuals have that have healthcare problems. And remember, our population, in most cases, come from situations where they didn't take really good care of themselves. And they have some very challenging mental health and physical health challenges as a result of that. So I can go on and on talking about what we're doing, but I'll stop here. For any questions that you all may have.
So I have a question about the side letter and those bonuses for folks who are being recruited. And you did say that for current staff, they are getting
Correct.
a bump. Are you hearing any pushback from the current staff about the new recruits getting those bonuses? Or do you think that $50
No, look,
every 8 hours helps?
I think, break down that $50 a shift, that's $6.25 an hour added to their pay. Now, let me say that again, $6.25 an hour added to their pay. That's a significant commitment. Now, that's not the only thing that we agreed to. I mean, we also agreed to a retention bonus for existing employees. And it's a fairly expensive package that we're still pricing out. But we are at the point where we came to the table through HR to negotiate that side letter with the union. I had a labor management meeting last week. Mr. Howard was there. I didn't hear it from the staff. What I heard from the labor management meeting and several conversations I've had with staff that they're appreciative of what is on the table right now to support them in a mode of retention. And I want to emphasize this strategy was retention. This is not, this is nothing about rewards or bonuses. This is about retaining the staff we have, the qualified staff that we have and the experience that we have in the facilities. That was the focus of the side letter.
Questions? Can't believe it. No questions. Thank you. Thank you. Steve? Welcome.
Thank you.
So as I stated before, you were scheduled for the Agency of Human Services staffing as well as DOC. So you could do that all together with the.
Where do you want me to, do you want me to start in a certain order, or do you want me just to?
I'm open to whatever works the better for you.
Okay.
If you want to just pick up where Commissioner Baker was, or if you want
Sure.
to do the Agency of Human Services first, whatever works.
I'll pick up with corrections first, and then I do have a few things to say about Beckett and the Agency of Human Services as well. Let me first start by saying that I agree with Senator Sears that this is a crisis. Crisis in the Department of Mental Health. It's a crisis in the Corrections Department. It's a crisis in the Agency of Human Services. And he is right that the starting salaries for these workers does not reflect the market. Those salaries, those benefits have got to be increased and enhanced, because these problems have not just crept up recently. These problems have been long-term and growing in nature. So I want to say that because I need to applaud Commissioner Baker for stepping up to agree to this package. And the other commissioners in state government should approach the bargaining process that is underway and follow his lead. But I have to also say, and I want to just point out that to get to this agreement, which our members are extremely grateful for, and it will be very helpful in both recruiting and retaining staff. It took their union a Herculean effort to get that issue, which was burning out of control in the Department of Corrections. Get that issue addressed took a Herculean effort. Several months of demanding a meeting with the governor. Several months of working through the process to get the people the commissioner said is absolutely right. People who are faceless. To get those faces in front of the man in charge of this administration. And as soon as we did, we saw a change. As soon as the governor saw the faces of these men and women, and he heard their stories, we saw a change. Suddenly the administration admitted there was a crisis. Suddenly the administration started meeting about the crisis, and then it led to this agreement. So I just want to applaud Commissioner Baker for his persistence in that and his consistency with that. And I want to thank the administration for actually listening to what people had to say, and making that transition. But I will say that this agreement really is just the beginning. It is, I think, a very generous package, and it is going to be very effective. But I think it's just the start of where we have to look if we want to address the crisis in corrections long term. And that includes looking at the retirement package of correctional officers in Vermont. And Vermont is sort of in an island. You're in Massachusetts, New York, or New Hampshire, you get a 20-year retirement at age 55, like a law enforcement officer does in Vermont. You don't get that here in Vermont if you're a correctional officer. And that is something that the VSEA feels very strongly needs to be addressed. I understand that's going to add to the cost of retirement. But if you think about the millions and millions of dollars that are being spent on overtime and the millions of dollars that are being spent on operating the system with people who are exhausted, that is an investment that is worth making. I also want to address, I think, something that our members, and I just want to say that before I come to testify in hearings like this, we ask our members, what do you want me to say? What should I say? What can I say that you don't think you can say, or you don't have time to say, or you don't feel comfortable? And they said a couple of things. And the first is sort of an elephant in the room, and that is the culture of the Department of Corrections and the disconnect between managers and frontline staff. It's not just about money. Money is an important component in the retention of the staff, but it's how valued those staff members feel and how heard they feel. It's the working conditions that they come to every single day. And I think our members have said that while they appreciated the legislature spent an awful lot of time on a report that the administration paid hundreds of thousands of dollars for about one facility based on one news article of allegations that were made. But in that process, never once answered the question, how is it that a facility like that has 6 superintendents in 7 years? What happens when you have 6 superintendents in 7 years? Why wasn't that part of the investigation? And so our members think that legislature needs to have a special focus on the management structure and the culture of the Department of Corrections, including answering that question. Why does a facility have 6 superintendents in 7 years? What happened? Where did those superintendents go after they left that facility? Because ultimately it's the superintendent who's responsible for what's happening in the facility. Now, to be fair, I think there's also a lot of questions about the growth of central office and the size of central office, especially in light of this crisis. And it's really incumbent upon leaders to lead. One of the things our members would like to see, and the commissioner will follow our lead, we have seen some members of the central office management staff volunteer to work in the facilities during this crisis, but we think the commissioner should assign those managers to work in the facilities, not just to help out with this crisis, but to see what the impacts of their decisions in Waterbury are in Springfield or in Marble Valley or CRCF in South Burlington. To build a team where people appreciate each other and can see that we're all on one team. And that is something that I hope, and we have asked the commissioner to do, we hope the commissioner will. It's also essential that the governor take charge of this issue and take charge of it as soon as possible. This is a crisis. And he really needs to look at this like it were a flood or a major snowstorm. We've asked the governor to arrive unannounced at facilities, at least one facility. And I know he did go to the academy, which is in great need of upgrade. We need to get a professional academy that isn't in an industrial park next to a producer of salad dressing. It needs to either be at the Windsor facility in Springfield, or it needs to be brought to the facility in Pittsford, or something more professional needs to be developed. So we appreciate that the governor went there, but the governor did not have unannounced on 3rd shift in Springfield to see what's going on there at 3rd shift in Springfield. He hasn't been to CRCF. He hasn't gone and said, I want the managers out of the room and I just want to talk to the front line of workers. And this is ultimately the governor's responsibility. This is his Department of Corrections that he has been hired to operate. And so we encourage the governor to do that, and also to create a direct line of communication. But it's not just the commissioner, because I appreciate that the commissioner does have these Wednesday town halls. But the folks who are on the front lines who are working 16-hour shifts, day after day after day, falling asleep on their way home, missing their family's events, or sleeping in the parking lot because they don't have time to go home, they deserve to hear from the governor every single week about what he is doing to solve this crisis. Every single week, he should be reporting, as the governor of the state, what he is doing to solve this crisis. It should rise to the level of need, the Department of Corrections especially. I want to commend, I do want to say, I want to be fair. We do have superintendents who are doing a tremendous job. So Teresa Stone is a good example. She's a superintendent at the Chittenden facility. She came out of her office and is working shifts on the front lines. The same with the SOS up in Northwest, but we haven't seen that with superintendents and facilities across the state as a common practice. We need them to come out of their offices, to stop watching the staff on cameras, and to participate in running these facilities during a crisis. That is leadership. Micromanaging the staff behind cameras in a closed office, that's not leadership. So we need to see some of those things change. There's a lot of concern about training, that members express that they feel that people are being pushed through the academies, that recruits are not given the kind of training that they need to safely operate in their positions in the facilities. And while they appreciate the effort of the Office of Professional Standards, they don't feel it's transparent, and they don't think just adding more managers in central office is the answer. One of the things that they stress to us is that the academy has been shortened from a 5-week academy to a 2-week academy. And that really is cutting back on the level of training that people need, that normally folks would train for 2 weeks in every post in a facility or with a field training officer. But because of staffing shortages, they're now just shadowing for 1 or 2 posts in the facility, and then they're thrown onto the floor. And that means that people in the facility for a year and a half have gone with no idea of how to cover an individual post. When they have to fill a post, they have to ask senior staff on the fly how to cover that post, which takes the senior staff away from the post that they're assigned to. And when you're in that kind of an environment, now these are brick buildings in 100-degree weather often, and you're in a very highly intense environment, and you're not given the training that you need to do your job, and you're not often able to get the help that you need to figure it out on the fly. That causes people to leave because they don't want to be in that environment. They don't want to be in a position where they're in fear of their own health and safety, and they don't feel they're being given what they need to get through that. I want to also comment on what the commissioner said, because he's absolutely right, that because of this crisis, we are taking people out of their field positions and putting them into the facilities. It's not often what they signed up to do or what they had done, but they're doing it. Many probation officers are volunteering to take overtime shifts, even though managers in central office haven't been assigned to do that. And some folks have been reassigned to the facilities. Now that should be a concern to the public, because that means there's fewer people checking on offenders who are in the community. And that is a real concern that our members have, that they are not able both to protect the public, but often to protect the offender. I had a discussion with someone who was very disappointed because he was in a facility covering during the staffing crisis, and he understood why he was there, but what he was upset about was on his voicemail, there were 2 voicemails from a young offender who he had been working with, who just moments after those phone calls overdosed and died. That's going to keep happening in our communities because these probation officers are often the lifeline for these offenders. So it's not just the public safety that's at risk, it's also the offender safety if we don't get the staffing crisis in the facilities under control.
So Steve, I'm looking at the time and I know that it looks like you have quite a bit of testimony. I know that we're running a little late. And we do have DOC scheduled again after lunch. So I'm wondering if you could finish up your testimony within about 5 minutes so that at least we can have a half-hour lunch.
Okay.
So if you could transition to the Agency of Human Services.
I'd be happy to do that. Just to sum up, I guess what I would say is the commissioner should get credit for his leadership in working with us to get to this agreement. Other commissioners should take the lead. The governor needs to step up and be more aggressively involved in this emergency, in this crisis. Our members need to see that from him. And there's a long way to go before we actually solve this problem in the long term.
So if I can interrupt here, and I know I just said, but sum this up, I cannot let this by without at least referencing legislation that occurred this past session and became law. It really was starting to address the culture within the Department of Corrections, the retention of our correctional officers, and also responsibility from within central office, as well as folks who are working within our correctional facilities. We put in a Department of Corrections Monitoring Commission, which, and I'm going to read right from the law, which is to provide advice and counsel to the Commissioner of Corrections with regard to the Commissioner's responsibility to manage reporting of sexual misconduct, promote adherence to anti-retaliation policies, ensure overall policy implementation effectiveness, improve the transparency, accountability, and cultural impact of agency decisions. This is done as an attempt to start working within the culture of DOC and turning it around. We've put in legislation, it is not the law. The other part of this legislation dealt with establishing a corrections investigative unit so that when there are issues, such as what happened at the Chittenden facility, there is an investigative unit that's going to follow up on these topics that comply with the federal law and to identify systemic issues within the Department of Corrections. We've started to put in the tools the Department of Corrections can start working in to start changing the culture. And I couldn't let some of your comments go by without laying down some of the foundation for the work that we did in both the House and Senate this year. And we are concerned about training of our correctional officers. And we did put in language in the bill that the Criminal Justice Training Council would work with the Department of Corrections to look at minimum training standards, investigations, processing, possibly certification or decertification of correctional officers. We have a report back coming this next session on this because some committees are really concerned with what you mentioned, what the Commissioner of Corrections mentioned about how Department of Corrections COs perceive themselves and each other. And we need to up that standard so that people can see they are in a professional job and that people do respect them. So I couldn't let some of your comments go by without explaining to the rest of the committee members some of the work that occurred this past session to address your concerns.
Well, I appreciate that, Madam Chair. And I would just say that our members really felt and feel that the legislature needs to take a significant look at the managerial structure of the department.
And you testified to that effect in our committee.
Yes,
on this bill.
and that it's not just a focus on the COs, but also a focus on managers. And for instance, should superintendents Should superintendents be in a collective bargaining unit? Should there be a way to protect superintendents who want to speak out, but are afraid of retaliation from central office? That may be a reason, that's an issue that should be looked at. Because we find that's, right now, the perception is superintendents are there to impose the will of central office. And instead, there's not a view from the front lines that in every case, there's some exceptions. I'd mentioned Superintendent Stone showing great leadership. But it's not in every case, but the perception is that they're there to implement what central office wants, regardless of what the front lines. And it's ultimately the frontline workers who are standing there before violent offenders and are having to deal with people who are committing suicide, who are fighting, who are doing whatever they're doing. So what we would like to see is a bigger focus on the managerial structure of the department. And now that there may be a new commissioner soon, you never know, it's maybe a good time to look at that structure and say, what can we do to break this culture that keeps information from flowing both ways in a way that the workers feel they're not being attacked by what's happening either in the state house or what's happening in central office.
So those are further conversations for when the session begins.
Sure.
So can you quickly just talk about the Agency of Human Services so that we can get into it?
Sure. I think generally I think what's really important in whether it's corrections or AHS, the most critical component in whatever the legislature is trying to do are the people who are hired by the state to do it. And that's really why there needs to be a significant focus on those employees and investing in those employees and compensating those employees and appreciating those employees in a way that feels to them like real appreciation. One thing that really does need to be, so I would just say that in general, across the Agency of Human Services, it's what you've heard so far is not different from what our members have said, which is that departments and offices are chronically understaffed, that this understaffing dramatically impairs the work of the state of Vermont and the well-being of the Vermonters that they serve, often people who are at risk, and that the understaffing is costing the state of Vermont millions of dollars. Traveling nurses are a good example of that. Overtime costs and corrections are a good example of that. Federal work in the Department of Health that can't be done because they're being redeployed to other issues is an example of that. Our members in many departments feel this pressure, but it's probably no more acute than in the Department of Health, which has led this state successfully through at least one major round of COVID and through another one, better than any state in the country. And they feel exhausted, and they feel disrespected, and they feel that they are not being heard. So when they speak out, and when they warn the public that more needs to be done to keep them healthy and that they may not be getting that from the political leadership, rather than being applauded by their commissioner, they are chastised by their commissioner. And when folks who are professionals in like the Department of Public Health, who have worked professionally to protect the health all of their lives, create professional work that is sent outside of their department to political appointees to edit and return to the department, that is demoralizing. That is saying we don't believe that your professional opinion is as important as the political narrative we're trying to sell, whether it's on COVID or whether it's on any other issue. So you have understaffing, but you also have the way in which people are being treated. People are being asked to do their regular responsibilities in the Department of Health and in other departments and COVID-related responsibilities. And there's no effort by the commissioners in many of those departments to do what Commissioner Baker did and recognize that and try to find a way to both change the culture, but also provide the compensation and recognition that people deserve. Now, you can have, it's nice to recognize people and say you support what they do, but it's really not your words that really matter to state employees, it's your actions. It's what you're willing to do to show them you support, not just that you say you support. That's sort of widespread across the Agency of Human Services. And I would just say on Beckett, I think our concern with Beckett is not so much will they take employees from other facilities, but will they be able to find employees at all? And will they be able to keep employees? Beckett has never done what they're being asked to do. They've never done this. And in the past, when they had youth who were at very high acuity levels, they returned them to Woodside, where the professionals nationally recognized by the Department of Justice provided therapeutic care for those individuals, and then returned them to a Beckett facility. Our members in DCF are very concerned that really the idea of Beckett is out of sight, out of mind. But as long as Beckett can keep these cases out of the press, keep lawyers out of the courtroom, and keep employees from being able to tell the truth in the State House, the management of DCF will be happy. And they feel that that's really why there was such a push to privatize this facility. The current DCF situation in DCF suggests that they really don't care about what the frontline workers are saying. Because right now, our go-to for these youth, the system of care that we have right now as we wait for this Beckett facility to come online, is that children are chained to chairs in police stations for hours at a time. St. Albans and recently in Newport. They are chained to chairs, and that is how the state of Vermont is taking care of the lack of a Woodside facility. We have children who are being watched at DCF offices. They're being driven around in cars by family service workers because there is no place to bring these kids. The Sununu facility requires an 8-day legal process in a judicial system that's also in crisis. But that's not even really an option. So our members are really concerned that we've created a bifurcated system, very much similar to the mental health system that Senator Sears referenced, where you have private employees who now don't have a union, cannot speak out, probably will not have the same wages and benefits as state employees, just as we have in the designated agencies. And there will be a fierce competition between those employees and those who have a union, which have won hard-fought benefits and hard-fought wage increases at the bargaining table. So it's really, I think for us, as we look at that, we have a real question about whether they'll be able to staff that facility at all. Because remember, privatization only works. It only works. It only works when you save money on the backs of the workers who are now going to staff the private facility. That was what motivated this whole discussion. So that's what our members really feel about the Beckett facility. I guess I'll just conclude by saying that we have a lot of work to do, not just in corrections and DCF and across the Agency of Human Services, in terms of compensation that reflects the market and reflects the value that we put on these frontline workers, but also the culture. The culture of state government needs to be addressed. And the legislature needs to play a significant oversight role in making sure that they hold those managers' feet to the fire in changing the culture of the Agency of Human Services, Department of Corrections, and throughout state government. Thank you very much.
Thank you. I think that sums it up well in terms of why we wanted to schedule some time to look at the staffing issues, both within the Agency of Human Services as well as within corrections. And I think that what Senator Sears said earlier, that we are in a crisis situation with staffing, is very clear in terms of what the SCA's testimony was the same. It's just how do we go forward in working together on how we can approach this. Are there any questions of Steve before we take a break?
Can I add just one more thing I just want to add, because I know there was a question about retirements, and there were significant amount of retirements. People, I'm going to just be honest, were very spooked by the proposal in the House early on in the session. I hear from I don't want to say hundreds, but significant numbers of very experienced state employees who are ready to retire now, who have the ability to retire now, but who would like to work more, both a benefit to the pension and to the state, who say that if the decision by the legislature is anything close to what was introduced last year, they're gone. They're gone. So all of these problems become even more pronounced if we don't handle that pension discussion very carefully with the reflection on our staffing needs in the state.
And I'm sure that you're talking to the pension task force.
I'm talking to a member right now. But we are working actively with the pension task force. I just want to make it clear because people have retired and there are so many more who have the paperwork ready and are just going to go the minute they think it's in their financial interest to do that. Thank you very much.
Teresa?
Question, but I just wanted to add to what both your commissioner and what we're hearing from Mrs. Howard, that this issue is across the agency of human services, and we don't hear about it in departments like Dale, for instance, but Department of Disabilities, Aging, and Independent Living, that they've been through 10 different directors in 12 years in one position, and that's wreaking havoc in the system. And the impact then again with the contracted providers that are really doing the frontline work, like designated agencies and area agencies on aging and stuff like that. So this, the chart that the Deputy Secretary presented is really sort of glossed over, frankly, from my perspective, the depth of the issues that we see, that we are seeing.
Just point to the Department of Human Resources does a survey of state employees, and part of the survey is a measurement of their morale. And if you look at the most recent survey, you'll see that across government, the morale of state employees is declining. It's pronounced in the Department of Corrections. Usually it's the Agency of Education and the Department of Corrections that are the worst. But across state government, you are seeing that morale of state employees go down, and that's a recruitment and retention issue that deserves significant amount of attention.
And I'll give a plug for that. Corrections Monitoring Commission is looking, the language we put in is to look at that survey. Incorporated that.
Thank you very much.
Thank you. So we're running late, and I know this afternoon we have DOC back with us to talk about the women's reentry facility in Maine, because some of you took a trip up there and how that's going to play into our replacement of the Chittenden facility for women. Would you be able, Commissioner, to give us a brief update on the body camera when we come back after lunch? Okay, can you come back? I'd like to take a half-hour lunch. If we could come back here a little, 1 o'clock. That'd be great. Thank you, folks who are zooming in. We're